morning, good afternoon, good evening, wherever you're joining us from, and welcome to today's event on the unintended consequences of the big tech antitrust bills. My name is Michael Karanicolas, and I'm the Executive Director of the UCLA Institute for Technology Law and Policy, which is co-sponsoring this event, along with the Georgetown Institute for Technology Law and Policy. We have lots to dig into and not a lot of time, so I will jump straight into the introductions. Daphne Keller is the Director of the Program on Platform Regulation at the Stanford Cyber Policy Center. Anupam Chander is the Scott K. Ginsberg Professor of Law and Technology at Georgetown Law. Bilal is the Senior Competition Counsel at Tech Freedom. David S. Korzenik is a partner at Miller, Korzenik, Sommers, and Rayman, LLP. And our fantastic moderator is Jane Bambauer, a professor of law at the University of Arizona, as well as a visiting affiliated faculty here at the UCLA ITLP. Jane, I turn it over to you, and I'm very much looking forward to this discussion.
Great, thanks. Okay, so we're here to discuss two bills that are rapidly working their way through Senate committees that are likely, or at least feasibly, may pass soon, that may have unintended consequences. And the reason there's a question mark in the title here is that it may be that even members of Congress have different goals and intents with how these bills are ultimately going to be interpreted. So, what we're going to do is first describe each of the bills. These bills are S-2710, which is the Open App Markets Act, introduced by Senator Blumenthal, and S-2992, the American Innovation and Choice Online Act, introduced by Senator Klobuchar. So we're going to describe these or refer to these as the Blumenthal bill and the Klobuchar bill. So what I'd like first is for Daphne Keller to explain how the Blumenthal bill is supposed to work, and then what issues, unintended or or whatnot, may arise from it. And then I'll ask Anupam to do the same thing with the Blumenthal bill, and then we'll be able to have a more fluid discussion. So I'm going to go ahead and get some text up and share my screen. While
actually, Jane, if you don't mind, can we wait and put it up in a couple minutes? Awesome, thank you. Just because, as Anupam pointed out, it gets so boring just looking at text. So I'm here to talk about the Blumenthal and Blackburn bill, Senate Bill 2710. And I just want to be clear from the outset, we need competition legislation. The concentration is at the heart of our platform regulation issues, including disputes that superficially look like they're about speech and content moderation. And I say this as somebody who worked at Google until 2015. So I take no issue with like 80% of this bill, which is the part that's about competition. What we're here to talk about is the 1% that raises serious content moderation and speech issues. And for anyone doing the math, the other 19% is about privacy, and it's probably a topic for another day. Also, to be clear, if you, like Ted Cruz, are excited about these bills precisely because they let plaintiffs litigate over speech and content moderation issues, I actually really understand that too. Having a few giant gatekeepers over the modern public square is a huge problem for speech and public discourse. It is the problem that competition laws are supposed to solve by reducing gatekeepers' power, not by creating backdoors to litigate for preferred speech rules or for whoever's in power in government to coerce the gatekeepers into adopting the speech rules that DOJ or FTC or state AGs or private plaintiffs want them to do. And that is the problem that I'm going to describe in this bill. Can you put the text up now, Jane? So the Blumenthal bill is about very large companies self-preferencing or preferencing their business partners in app stores. And let's assume sort of the Android or Apple app stores are our examples. This bill has a private cause of action, so individual businesses can sue. That distinguishes it from the Klobuchar bill that Anupam will be talking about. And the legitimate competition part of the bill is these plaintiffs can sue over app store price controls, or if, say, Apple makes them use its payment system. It introduces a mandate for side loading, meaning device owners can get apps from somewhere other than the Apple or Android app stores. And continuing in the still legitimate, if complicated, real competition parts, app developers can sue if Android or Apple preference their own results, preferencing Google Maps, for example, or Apple News in their ranking systems. But here's the speech policy part. Those plaintiffs can also sue if the App Store is treating one private app developer differently from another private app developer. So if there are two apps in an app store, and one of them says, you should treat me the same way as that app, they can sue over it. And this should sound familiar to anyone who deals with content moderation, because it's what plaintiffs have been saying over and over in so-called must-carry cases, which are happening constantly. I wrote about them a few years ago in an article called Who Do You Sue? As of then, there had been maybe 30. Now there have been probably more like 70. These are cases where white nationalists like Jared Taylor or apps like Parlor say they have a right to be included or to be ranked highly or to be allowed to monetize content on platforms. These are the suits that we're talking about. Now, back in the text of the bill, the most important limit in this bill is that the plaintiffs can't just say they were treated unfairly compared to any other app. They have to say they were treated unfairly or subject to unreasonable preferencing in the bill's terms compared to business partners of the App Store. That's section 3E1. And you can see what the drafters probably wanted to get at by making this about platforms prioritizing their business partners. But here's the problem. Giant platform companies have some kind of contract, some kind of business relationship with massive numbers of companies, from major deals to ads contracts to just the contract that's signed with every app developer. So Apple for sure has contracts with Facebook. That opens the door for Gab or Parlor to say, hey, Apple, treat me like Facebook in your app store. Apple and Google both have deals with major media in relation to their news services. So that gets you, say, the Daily Stormer app saying, treat me like the Wall Street Journal or CNN. Google has ads contracts with all kinds of tiny publications. So that gets you a small white power group saying, treat me the same as the app from this Black Lives Matter affiliated group. And then you're off to discovery and litigation about what constitutes legitimate enforcement of platform speech rules under what was nominally a competition law. Continuing with the text, the plaintiffs don't have to say the different treatment was commercially motivated because the prohibited unreasonable preferencing is defined to only include commercially motivated, or as it says here, prioritized based on a criterion of ownership interest scenarios. So they can bring claims based on other things besides that under the language of the text. And the question for that litigation won't be what the words of the statute meant to some of its supporters or even the people who wrote it. It will be what the plaintiff can convince a judge it means. And other panelists will talk later about how the litigation really will play out. My personal take is that platforms will just fold under pressure a fair amount of the time. And then when they don't, when this actually goes to litigation on these must-carry claims about speech and moderation, plaintiffs will sue often enough, roll the dice often enough, get in front of enough different judges that they will get somebody who agrees with them, because this text does not have a clear meaning. Anyhow, so one more statutory thing. If the suit gets brought, let's call it Hate App Inc. versus Google or Disinfo App versus Apple, that gets us to the last little line in the statute that's relevant for our speech issue, which is that the platform can defend itself. This is down in section 4. Do we have 4 up? Good. The platform can, sorry, now I'm losing my place. Defend itself if it shows that its decision was made on based on applying its policies on a, quote, demonstrably consistent basis. So can platforms in fact prove this? And Jane, we don't necessarily need the text anymore from here on. Can they prove that they were consistent in applying their content policies? No, they cannot, because first, content moderation at scale always involves a margin of mistakes. And second, because people simply don't agree on what it means to be consistent about hard judgment calls. There are a million examples, and they're often about real flashpoint, like culture war type issues. So if a Black pride group is organizing a rally and a white pride group is also organizing a rally, is a platform consistent if it takes both of them down, or is it consistent if it applies different rules based on differences in history and society? There's not really one answer to that, and a court that is motivated or a plaintiff that is motivated could make either of those arguments. So, or is what? If it's sorry, it's someone is in history and society. I'm not sure who that was, and I couldn't hear. I'm just going to wrap up here. Whatever you think the answers are to those.
It was your echo.
Oh, whoa! She sounded so articulate. That was great. Whatever you think the answers are to these substantive, like really important speech and culture questions, getting them in front of courts by sneaking them into a competition bill is not the way to achieve them. And assuming or hoping that courts will read these provisions in the way that their drafters probably intended, instead of reading them the way I just described, is a gamble. So that is my take on the Blumenthal bill, and I think I'm handing off to Anupam for the clip.
Can I ask, actually, before we talk about the other bill, let me just like ask some clarifying questions or make sure that my understanding is the same as yours. Is that even though, at least in public media and maybe the introducing senators themselves think of this as an antitrust bill, I hear what you're saying is that it's actually as much a kind of public accommodation style of bill that's relevant in the content moderation debates, because it's not only self-preferencing for business reasons that is being targeted, or for anti-competitive reasons rather, that's being targeted. It's self-preferencing for any reason, including possibly for public safety, public to be a good, responsible corporate citizen or something, any reason that winds up falling within the parameters of these rules will be treated as the subject of litigation. Is that right?
It's any preferencing of an app that has some kind of a business relationship.
But for any reason is what I'm getting at.
Right. And then that's the New York Times app, that's CNN, that's the Wall Street Journal, that's, all kinds of things. And then, it seems pretty clear to me that the drafter's intent is this is supposed to be about commercially motivated decisions, but that's not what it says. There's also, I think, as probably Bilal is going to talk about later, there's language in here that sounds like it's language from competition precedent, but isn't exactly, and sort of, opens up the possibility for plaintiffs to say it means something else, courts to conclude it means something else, and so forth.
Yeah. Okay. So in Parlor versus Apple, for example, if Apple says, well, yes, we demoted or denied access to our platform because of public safety reasons, because of general public safety reasons, that is not going to be. It maybe at best it's a defense that would have to be proven within the parameters of the defenses in the statute, but in any case, the fact that it was that it was motivated for something other than anti-competitive reasons would not disqualify it as a good lawsuit under this act. Is that right?
Right. And this is actually literally what Parlor was saying in its lawsuit against Amazon Web Services. Right. Was they were saying this was motivated by your commercial relationship with Twitter, saying we are analogous to Twitter, and so you have to leave us up if you're leaving Twitter up. And this leaves the platform having to prove that they were applying their policies consistently, whatever that means, because there are 20 different interpretations of what that would mean.
Okay, great. Anupam, can you take us through the Klobuchar bill?
Sure. Thanks so much, Jane, and thanks, Daphne, for a masterful presentation of the bill and some of its risks. As Daphne pointed out, these bills sound in antitrust, but they actually have consequences that we believe extend far beyond antitrust. And I'm going to continue spelling that out here by looking at the Klobuchar bill.
By the way, as I get the language up, I meant to explain that the bold text in here These are amendments that have been made in committee that are not reflected on the public website yet. And so I put it in bold so that audience members who may be looking at the public, .gov website understand why what the text that you're looking at here is different. Okay, go ahead.
Okay, thanks, Jane. And let's actually take this, let's stop screen sharing for a second, and I'll call it up in a second. Thank you so much. So let's talk a little bit about the background of this bill. The Klobuchar bill is sponsored also by Republican Senator Charles Grassley. And on its face, it targets self-preferencing by big tech companies. And as Daphne said, there's a lot that's, that is important in a bill like this. And I'm not taking any position on the antitrust aspects of this bill, but on some of the other consequences here. The bill is targeted at the largest tech companies. It reaches really only the very largest. It has a minimum $550 billion market cap requirement or net sales requirement to be for a covered platform. And that means basically Apple, Amazon, Facebook, Google, and I think Microsoft. That's the way I read it, at least, though some may disagree about whether Microsoft is covered. But I would think Microsoft is covered as well. Microsoft has a huge amount of cloud services. If you look at how the online platforms are defined here, 365 seems to satisfy the definition. Just as an aside, for any Microsoft lawyers out there, I would pay attention. So this is a bill that has at its core Section 3. And Jane, if you want to now show Section 3. So Section 3, as you can see, declares what is unlawful conduct under the bill. So let's look at the first and third paragraphs here. So one would be unlawful conduct where you are self-preferencing in a way that will materially harm competition. Or the third provision here, discriminating in the application of terms of service among similarly situated business users, again in a manner that will materially harm competition. So let's take that down again. So far, so good. The act on its face seems designed to do what we want, which is to ensure that big tech enterprises don't favor themselves or their preferred business partners. That's overall a reasonable goal. But I want to argue that the end result of this act, which is designed to make a better internet, will be an internet full of more racist and sexist hate speech. There are many noble motivations here, but the act hands a powerful weapon to state AGs or to any future Ted Cruz DOJ, a weapon to go after internet companies that dare repeat what happened to the right wing in 2021. That is the deplatforming that took place in 2021. So let's come back. If you could bring the next slide up, Jane. So let's talk a little bit about the next provision here, which are the affirmative defenses. Yes. Okay. So here it provides affirmative defenses. So let's imagine you're sued, and I'll talk about the suits here. The affirmative defenses are very narrow, and they are affirmative defenses. The platforms would have to show this. First, they'd have to establish by preponderance of the evidence that the conduct was narrowly tailored, non-pretextual, and reasonably necessary to protect safety, user privacy, security. Okay. Now, what about protecting against racist speech? What about protecting against cyber harassment, which isn't designed to incite violence? Those are not actually even defenses under the statute, as far as I can tell. So it's not clear that you can even win even if you can show that your conduct was narrowly tailored, non-pretextual, and reasonably necessary. Okay, let's take this down if you wouldn't mind. So the argument here is that there are substantial parts of this bill that hand this incredible weapon to motivated actors here. And what would that look like? So the bill begins by stating that we'll make unlawful certain discriminatory conduct by covered platforms. But that's where the rub lies. The platforms are engaging in what people will feel is discriminatory conduct all the time. They are constantly saying your speech is okay and another person's is not. And that is exactly the kind of discriminatory conduct that can be challenged by a state AG in the future. So the question is, as Tech Freedom has put it, will this statute become a bill of rights for right-wing sites like Parlor or Gab, or Stormfront even? In fact, this isn't just a law professor hypothetical. After Amazon stopped hosting Parlor through Amazon Web Services, Parlor sued, arguing that Amazon was abusing its power to protect itself, to kneecap a competitor, as NPR put it. Jane, do you want to show that lawsuit?
Do I want to share the lawsuit?
Oh, I'm sorry. Do you have the next slide? I don't know if you have the next slide.
Oh, I don't. Let me see.
Okay. Sorry.
I don't think I have a lawsuit in the slides. If I was supposed to, I'm sorry, I didn't make it in.
Okay.
Yeah, it did not make it in. I'm sorry.
No worries. No worries. Okay. Sorry. I'll just pull up the text right now. Sorry about that. Okay, so in 2021, when Parlor was deplatformed, and I can probably share my screen here. Parlor sued, and here's its lawsuit. It said Amazon was a bully. Many startup companies have appeared to be a threat to Amazon and AWS, have felt their wrath. Parlor LLC is merely the latest casualty, a victim of Amazon's efforts to destroy an up-and-coming technology company through bad faith conduct. Before the actions, plaintiff had one of the hottest rising apps. It positioned itself as an alternative to the likes of Twitter or Facebook, and it didn't use surveillance capitalism, Parlor informs us. So this is the exact kind of claims that would fit perfectly in Section 3. And so, I think there is reason to take seriously that this does end up becoming a Parlor Bill of Rights. And I think we should be cautious about that. So let me just make a couple more points. Let me stop there and we can come back to further discussion.
Okay, great. So Bilal and David both are seasoned litigators in cases that involve especially media companies, but more generally, antitrust or anti-competitive claims against companies. So I'd love to get your take. Well, actually, let me first ask a follow-up question to Daphne and Anupam before we ask the antitrust, put the antitrust lens on, which is, to the extent that people are disturbed, as Daphne, I think, alluded to herself somewhat being, to the extent people are disturbed that a few companies can basically block an app that joins together people from people who have a political interest, or at least a quasi-political interest. Why isn't antitrust or why isn't a bill that's trying to deal with competition problems an appropriate way to manage that? Rather, maybe the more articulate way to ask this question is: are consumers harmed? do we think generally consumers are harmed if they want some kind of an app that Google or Apple or Amazon thinks is bad for society? Is that a form of consumer harm that should go into antitrust analysis?
I will defer to the antitrust experts on the kind of consumer harm that's cognizable in antitrust. But the reality of large platforms moderating content is a serious one. But we also know that there are plenty of opportunities for other smaller platforms not covered to host speech. So there's no end of right-wing speech available on the internet. And so I'm myself not particularly troubled by Facebook saying, we're not going to host racist or sexist or other kinds of hate speech on our site. We're not going to host particular kinds of bullying. Now, I know they don't do that well enough, so I'm not trying to say that they've done a good enough job of that. But I think if we look back to the inside whistleblower revelations from last year, the focus was on their failure to take down material, not the fact that they left stuff up. And I think this bill pushes in the exact opposite direction. It actually worsens the internet that we all want.
Yeah. Okay, yeah, so I mean, go ahead.
But I think the answer might be different for app stores. Right. And I, like Anupam, I am not speaking to antitrust standards of consumer harm. I'm definitely not an expert there. But app stores and mobile devices themselves are kind of the tightest bottleneck in our information distribution system, right? We are accustomed on our regular computers or on the World Wide Web to be able to find whatever content we want, even if it isn't on the major platforms, or to download and use the code that we want, if we feel capable of doing that. And on mobile devices, particularly iPhones, that's very locked down. You don't have those kinds of choices. And so I think, whereas if a message isn't on Facebook, you can go other places to find it. If an app isn't in Apple's App Store right now, you can't put it on your iPhone at all. And that's kind of a different question about competition.
Yeah, so within one particular form of hardware, maybe there is more of a bottleneck and maybe there's more of an issue. On the other hand, I guess what I'm concerned about is that maybe not even completely consciously, consumers may in fact use the Google Play Store and the Apple App Store as an intermediary to make some basic decisions, some threshold criteria for the sorts of apps that are or are not provided. I think a harder case might be something like Parlor, where people are highly sensitive and aware of whether they do or do not want to access it. But maybe a better example would be an app that depletes your battery power, or that has some other that has some other mischief that just isn't good enough for the App Store, that now could still claim some kind of an anti-competitive harm here. Okay.
100%. I mean, the good thing that App Store moderation does is protect consumers from security threats, privacy threats, fraud. There's all kinds of bad stuff that most consumers want their app stores to protect them from. But then if the app stores leave everyone with zero option to ever go beyond what the app store providers decided, that's a bigger consequence than if we were talking about the open internet.
Okay, great. So let me get David and Bilal in. David, you've litigated many cases involving media companies and including sort of claims of anti-competitive claims. So what's your take on these bills and how litigators are likely, litigators or state AGs or whatnot are likely to interpret it? Oh, you're on mute.
There we go. Can you hear me? I want to refocus it a little bit in terms of what I do and the way in which I look at this. So my firm and I represent news organizations and content creators, and we defend their content against all enemies. So we are obviously look at any efforts to control content with alarm and through a First Amendment lens. We will not represent, and we don't represent plaintiffs in any of these things, including copyright, fair use, and so on. Now, when you look at this legislation, at least I see it as part of a bigger picture here. As was mentioned by Daphne, there is a culture, all of this is happening in the midst of a culture war which has in many ways sensitized us all to the social media platforms because they seem to be the vectors of all of our troubles. The right sees it as if it's dominated by the left, and the left sees it as if it's dominated by the right. And they're probably both wrong as to different types of things. But the object of the whole battle is to control content, to control speech outcomes. So this legislation is among a group of legislative efforts with some of the same people. One, to possibly give Section 230 a haircut. That's on the way, and there must be about 12 different bills to figure out how to do that. There is the Haugen testimony and new legislation by Blumenthal as well, I think, to protect children against social media and the internet. All valuable in many different ways. There's this antitrust legislation intended to control platform practices. And significantly, hovering ominously in the background are the dissents of people like Gorsuch and Thomas, who intend to give New York Times versus Sullivan a haircut, all because they think that by doing so, they're going to somehow improve the media environment. Now, what's interesting is that part, as Daphne and Anupam point out, there are legitimate business objectives to this antitrust legislation. The problem is that even there, even in its most plainly economic kind of objectives, it's confused. And it's confused in this way. On one level, it wants to create an environment in which there are a multiplicity of voices, the learned hand model, the Adam Smith model. But on the other hand, it also wants to impose a kind of public square must-carry model. And it uses both of those things, both of those metaphors and both of those notions to drive its economic features. And I maintain that those are confused. What I do think we ultimately want is, we do want platforms and websites and so on to be able to curate their content. That's what we go to them for. And if they present a certain point of view, that is their First Amendment right. It's not something that is wrong on some kind of antitrust level. We want them to be able to curate. We want them to be able to critique, comment, object to postings and third-party material the way Twitter did. We want them to do so. And in fact, in Section 230, that's the whole point of Section 230, is to actually enable platforms to be the good Samaritans and to moderate when they can.
And would you say those same principles apply to app stores or app stores platforms that manage? I mean, apps themselves are, of course, ultimately just digital instruments of information. Would the same principles apply either in policy or in terms of actual First Amendment doctrine?
Yeah, I mean, it's funny you raise that word, apps and app stores, because when you use those words, it looks as if, okay, well, they're just selling those little widgets on your phone. But the statute isn't defined that way. The statute actually says that an app is an electronic service. Well, that's everybody. And that's a very much broader spectrum of actors. So, while, again, I don't think we have a lot of time for it, but say, for example, when you look at the Klobuchar bill, Section 2B3, here's a section that looks kind of innocent, but in fact, what it's doing is preventing us from intercepting social media manipulation and deplatforming, say, an application or a service that is actually pumping, that is a creature of, say, of a Russian troll farm, or of Cambridge Analytica, that are basically pumping sludge through our communication arteries. So look how it works, is to use non-public data that are obtained from or generated on the covered platform by activities of the business user. Well, how does Facebook or any of the other groups, to the extent they do this, how do they intercept this type of manipulation? They do it by monitoring non-public data of the user that they gather from the user's activity on their site. We want them to do that. We want them to intercept manipulation. This bill complicates that practice. And every one of those provisions, and I don't want to eat up time doing that, but what they're doing is, if you look closely enough, they are frustrating and putting at risk content moderation. They're frustrating and putting at risk the interception of social media manipulation by foreign governments. And by the way, a lot of this is about propaganda, just as it was in the 1930s when we were dealing with a new medium called radio. And Mr. Goebbels and others who knew how to use it better than we did, at least at the outset. So it complicates and frustrates content curation. It complicates and frustrates critiquing and labeling misinformation, which is exactly, again, defined within this statute as a prohibited activity. So what I think has to happen, since no one's going to clean this up, and everyone is so hysterically eager to somehow rein in the social media platforms, the only way this thing can go through is with very distinct carve-outs, explicit no-fly zones that say tell the courts, that tell judges that this is not what it's about. It is not permitted to interfere with content moderation. It may not be used to prohibit curation, and so on, and all the things that I've pointed to. That's crucial. Otherwise, this thing turns into the kind of ugly sewer that Anupam just described. There's one other thought that I'll throw out that I think is possibly interesting. It strikes me that not only should there be carve-outs, no-fly zones, clear statements of what this legislation will not do and will not impede, but it also needs to have a built-in shield law, let's call it that. Areas of discovery that are not permitted. You may not use these claims in order to interfere with the editorial process or to obtain discovery of the editorial process. You may not use discovery to advance these claims in order to subpoena curatorial process, and so on.
Mm-hmm. Maybe even an anti-slap reverse damages.
We're in that vein, absolutely. So I think you need carve-outs, no-fly zones, and you need to have a built-in internal shield law that protects those processes. I'll make just one final point. The language of this stuff, as Daphne and Anupam pointed out, is rife for litigation. When they talk about damages, they use that would cause, that would do this. We've been through this before, for example, in the anti-dilution law, where they use the saying that would cause dilution. And the courts tried to rein in that law by saying that it required actual harm. Supreme Court in Mosley says no, it says you have to show actual harm. The owners go back and legislate in a lesser standard. And that meaning that type of litigation becomes metastatic. So
Okay.
those
Yeah,
are,
so I want to move to Bilal because Bilal, by the way, was the former director of FTC's Office of Policy Planning, and so is particularly well steeped, I think, in antitrust law and from the FTC perspective, at least their goals and mission. So Bilal, this looks to me kind of like this looks to me like a bill that basically creates a duty to deal, which makes me think of cases like Trinco, which I don't know very well, but but you do. So could you tell us, how these acts relate to sort of traditional antitrust and maybe more importantly the differences and what those differences will mean in pragmatic terms?
maybe I can do that.
Okay.
But I also want to make another point or two that I think may have been sort of overlooked. But let me answer your question first. I think there is a concern that both bills basically establish a duty to deal. The Klobuchar bill appears to have what I call better defenses for not dealing with everybody, but I think it also includes some limitations. The Blumenthal bill, though, reads to me as a duty to deal bill with limited exceptions, and particularly limited exceptions for reasons that are consistent with economic efficiency and general business justifications for refusing to deal with everybody or being selective in who you deal with that have been accepted in antitrust law. Now, the reason the courts have given and the academic literature has given for not imposing a duty to deal on either monopolists or firms, except in the I'd say narrow circumstances for monopolists, is a concern that duty to deal with everyone, precludes efficient conduct or innovative conduct. You, in a sense, want to sometimes align yourself with particular downstream or upstream firms. Here, I'm not speaking necessarily in the content space or in this space, because you want to align your interests, right? So antitrust has not, over time, has moved away from requiring a duty to deal, and only in the most narrow circumstances does antitrust impose such a requirement on single monopoly firms with monopoly power or large firms. And of course, it's a question whether a firm has monopoly power, and these bills don't even pretend to set forth a basis for assuming or concluding that these firms have monopoly power. But let me highlight something else that I think is sort of notable. It's not only that arguably these firms establish a duty to deal. Only one of the bills has what I'd call sort of a harm to competition requirement, right? That discrimination can be efficient, and only one of the bills sort of provides for an efficiency defense or defense that the discrimination did not harm competition. So let me comment on Klobuchar's bill, because that's the one that's I think a little bit better, but also has some problems that may not be recognized, right? And I'd say the bill was improved by the markup and amending process, but it still may allow for too many unmeritorious claims. In particular, one that we're discussing here, which is a firm who has been excluded or in some way discriminated from access to a platform because of content disputes may be able to dress up their claim
or may be able to dress up a antitrust claim or a competition claim to apply pressure to the covered platform or covered entity to give them access back, right? So Klobuchar's bill focuses on discriminatory treatment. I think, as others have said, a covered platform cannot treat a business user different than it treats itself, and it cannot treat similarly situated business users differently. And I'm going to treat self-preferencing as a form of discriminatory treatment, right? A covered platform ranks itself above its competitors on the platform. As I said, there are affirmative defenses, and there is generally a requirement that the discrimination have a material effect on competition to be illegal. The discrimination must cause material harm to competition. Now, there's one antitrust statute that focuses on discrimination, right? And that's the Rayman Act. That act has been correctly criticized for protecting less efficient competitors from competition for more efficient competitors, and sort of precluding efficient relationships between firms, right? The Rayman Act addresses the same type of discrimination, competition between competitive firms where the firm engages in conduct that discriminates against its competitor, and where a firm engages in conduct that discriminates between two firms that compete against each other. Now, the provisions of Klobuchar's bill are similar, and I think we can learn a bit from our experience with the RP Act. But first, I'll note that this bill, the Klobuchar bill, incorporates new harm language, unlike language we see either in antitrust case law or in antitrust statutes in the Clayton Act and Section 2 of the Rayman Act, right? Generally, what you've seen is parties need to show that a practice may substantially lessen competition or tend to create a monopoly, or in the case of a monopolization claim, show illegal monopolization. The bill incorporates new harm language, right? The discrimination or the self-preferencing must have a material harm to competition. Now, that new language is different. It is intended to be different. It is intended to be a lower threshold of showing of harm. And I think it opens up substantial uncertainty as to what a plaintiff must allege to successfully proceed past the motion to dismiss stage.
Yeah,
right?
so let me just make sure, Bilal, so is that threshold for harm low enough, and would everything else in the bill provide a path for Parlor to use our sort of key case example for Parlor to claim that the Apple Store must carry their app?
Well, it's a good question, and I think I have. I think the bill attempts to prevent some such claims by giving enforcement authority only to the Department of Justice, the Federal Trade Commission, and state attorneys general, right? So Parlor itself cannot bring a claim under Klobuchar's bill.
Although perhaps they could strap a claim under unfair competition law, state act.
Well, so first I was going to say the Blumenthal bill does not include this kind of limitation on private rights of action or private plaintiffs, and that's a significant problem because their incentives, may differ from government actors. Now they can bring a private plaintiff can try to sort of bootstrap a claim under of discrimination, inconsistent with or prohibited by the Klobuchar bill. They can try to bring that under state law prohibiting either unfair methods of competition or unfair acts or practices or some other sort of unfairness or antitrust statute. And the bill itself, right, would not preclude a state court from trying to what I'd say analogize or analyze how this claim would be analyzed under state law without regard, to federal law, right? I think what we might like to see if this bill did move forward is sort of a narrowing of who can bring these claims, and that, the conduct, the illegal conduct or the prohibited conduct in the Klobuchar bill, or even the Blumenthal bill, that cannot be the basis for a state claim, and that state courts, to the extent they entertain or can entertain such claims, must look to federal law to evaluate such claims. But the better course is to avoid, development across 50 states under their state antitrust or state consumer protection laws.
Okay, great. So we only have 9 minutes actually. So I want to make sure that I give the other panelists a chance to react to all of this and then bring up a few questions in the Q&A. Daphne, Anupam?
I'm happy to go straight to Q&A.
Okay, good. One question, so someone asked a section 230 question, but that came before David gave his remarks. So I'm gonna actually skip to this question about to what degree does the addition of inorganic search results mitigate some of the issues that we're talking about? My sense is that it actually doesn't do much to help mitigate, but can you explain why, Daphne?
So, I assume that was put in there to clarify that this doesn't apply to ads, because usually the distinction is either it's ads or it's organic search results. So I don't think it's doing.
So organic search results still, right, exactly. Okay, so that's, and an ad, I think actually the bill says the ads have to be labeled as ads too. So, so almost everything is that we're, practically speaking, everything comes through organic search results.
Yeah, removing something is discriminating in organic search results.
In organic search, exactly, yeah. Okay. The Sherman Act has also been read to carry an exception for First Amendment petitioning activities. Oh yes, okay, so this came up. We've actually already sort of addressed this. And then in the chat, Mitchell.
Jana, I feel like it might be useful to talk about First Amendment a little bit more.
Go ahead.
Just because the most important sort of trump card that platforms have had in these must carry cases so far is the argument that David raised, that they have an editorial right under the First Amendment to decide what content they want to carry. And I think under the case law so far, that is correct. But I also think this is potentially in flux. We have really interesting statements from Clarence Thomas and also from Justice Kavanaugh back when he was on the DC circuit about ways they might come at this that are different from the existing case law. And so, while I think platforms do have a First Amendment trump card now, enacting a law that gives congressional endorsement to a claim and seemingly provides a congressional reason to override their platform's First Amendment rights could really change the calculus and provide the pathway through sympathetic judges to revisit this question at the Supreme Court.
Oh, David, you're muted.
Yeah, it does seem that they are looking for that kind of rationale, and you can see it in this kind of public square analogy that they're trying to develop. But I'm not really sure where that ultimately goes, because they themselves don't like any of the forced speech concepts. And so I think they're in a quandary. I think that I don't think that they can make that one really work. And remember, we did try to make that work in the 30s, certainly, and later on with TV, where we had scarcity as the rationale for that. But
right. Replace scarcity with dominance, and that's what you get with today's conversations, I think. Right.
So I'm not sure that there is scarcity here.
No, I know, but what I mean is the language has shifted from spectrum scarcity to the language of dominance. Tech right. Companies are dominating or bottlenecking, and yeah.
Yeah, that's a good point. But I still don't think that's going to work, but it's ominously there, and that's where they're looking.
Okay. Let's
But
see.
the 230 question is interesting as to whether it would cross wires with any of these bills if they were to become law.
Yeah, and I saw in the chat, there are at least some cases in lower courts interpreting app stores as what are they called? Computer services under Section 230, right?
But I mean, the plaintiff's brief writes itself here, right?
Yeah.
This is not a claim about publishing. This is a claim about competition. Look at what the name of this law is. Look at how Congress has acted subsequent to 230 to change the law.
Yeah,
and then does a judge buy that? Up to the judge.
Yeah, imagine an API denial, for example. Is that sound like something that might be a 230 claim? You might deny Clearview AI access to your API because you're sick and tired of its, downloading all your photos. So is that, and you might yourself have a facial recognition system in place. So lots of opportunities for mischief.
Yeah. So let me ask maybe the more general question about where net neutrality, to the extent that we want it, should end, right? So if basic internet service providers are expected to carry everything without doing active kind of discriminating between good and bad, well, actually they do some discriminating between good and bad actors, but outside of security, if they're expected to carry everything, no matter how sort of awful the content may be, does that, it seems to me that the debates today are taking that concept and just moving it up a level on the stack and insisting that therefore platforms more generally, or at least some specific platforms that seem to be dominant, must also abide by those same rules. Is that, do you think, is that what's going on here, or where do we draw, I guess, where should we draw a line between wanting to make sure that there's an all-comers, equal opportunity, competitive platform versus wanting to authorize and enable platforms to actually be good, responsible citizens and actually help their end users be in an environment that they, that isn't like 8chan and that is what they're expecting and wanting.
Someone raised an equal protection argument in the Q&A chat, I guess, and I'm not sure exactly how that would shake out. What's the state action kind of issue here? So I'm not really sure I get it.
I think it's most relevant in cases like the hypothetical that I raised, where it's different treatment of groups or apps based on, the stated racial identity of the app developer. And I do think that equal protection based claims or discrimination based claims play a little differently in relation to the First Amendment and Section 230, but I just don't know enough about competition law to say how they play differently in a law like this.
Okay, great. Well, we're almost at the top of the hour. So seeing no new questions come in, I'll go ahead and give you the opportunity to say one last sort of thought on top of mind, and otherwise we can wrap this up. All right, everyone's being very polite. So we'll see.
Is that there does seem at the end to be this conflict between different economic models that are confused within the statute, so that even its economic objectives seem to me to be internally in conflict as to whether they want a lot of multiplicity of voices or whether they want to simply have the powerful voices forced to give voice to other voices. And I think they're confused. I think that the multiplicity of voices is what competition really is about. It's not about forcing any one speaker to bear to carry the message of another. But they're confused as to what they want to do here.
Daphne?
I I've said my piece.
So let me just say something very quickly. The one thing that is striking here in the interest groups that are represented in the Klobuchar bill, you see the copyright and trademark interest groups represented. And they, you know what they get? They get a carve out from the definition of unlawful conduct. They don't need an affirmative defense. So a platform that is trying to protect copyright or trademark interests, or 1201 under the DMCA interests, that is not even unlawful conduct under the statute, and doesn't have to then show any kind of narrowly tailored protections that are non-protectual for those purposes. So that tells you a little bit about what interests are on the table and where my interest as a person of color lies in all of this.
Well, thank you, everyone. This helped me at least understand these bills better.